Welcome to Coastal Funeral Center and our Community Partnership series of videos on financial planning, wills, and trusts. My name is Sharon Kalani, and I direct business operations here at Coastal Funeral Center. And today's segment is going to talk to us about what is a special needs trust. Today we have a special guest, Mr. Chaz Shields, the founding attorney of the law offices of James C. Shields in Torrance, California. Welcome.
Thank you.
It's my honor,
Good to
sir.
be here.
Glad you're here. So let's get right into it. What is a special needs trust?
Summarized a definition because I talk about them all the time and sometimes I miss something that's important. So I'm going to read for just a moment. A special needs trust is a legal arrangement designed to benefit individuals with disabilities without disqualifying them from means-tested and some non-means-tested government benefits. Most commonly, they're used to protect benefits for those individuals from supplemental Social Security, Medi-Cal, so they can receive the full benefit, and the amount that's provided to them in the trust is not used to either disqualify them or reduce the amount of government benefits available. Now, some of the less commonly known benefits that a special needs trust would also protect include Section 8 housing, in-home support services, regional center provided and paid services, and services provided and paid for by the California Department of Developmental Services. That's basically what a trust does. It's a means of leaving assets, money, including money, to or for the benefit of a loved one who would be receiving these types of benefits currently or projected to do so in the future without compromising those benefits. So basically, it maximizes the total funds available to that individual who is the beneficiary of a special needs trust.
You mentioned about someone listed in a special needs trust. Tell us a little bit more about that and how they're protected. You had mentioned benefits.
A trust includes three parties, if you will. There's the trustor, grantor, that's the person who creates it and puts assets into, funds the trust. And that's very important that that be done properly. They appoint a trustee. It could be themselves during their lifetime and capacity, and then a successor trustee who would step in and manage the trust for the benefit of the most important party here, who is the beneficiary. The beneficiary is the person who is benefited by the trust. Those are the three major parties, and essentially, again, what it does is the trust is a vehicle that's funded by the trustor, money, bank accounts, other assets that are put into the trust for the benefit of and to be managed for the beneficiary of the trust. Trustee's job is to do that, manage it for the benefit of the beneficiary. And there is a very strong statutory law in California that imposes duties on the trustee to act in the best interest of the beneficiary. They can be administered either independently, that's without court supervision, but the beneficiary or any other interested party always has the option of filing an action in Superior Court for an accounting of the trustee's duties to make sure that they're acting in the beneficiary's best interest.
So what do you suggest? Who should be the trustee in a situation where, parents want to make sure their special needs child is cared for the rest of their life? Who should be the trustee?
Somebody who loves, cares for, and is capable of providing care, not direct care, but managing the assets for the beneficiary of the trust. Additionally, they should have the capacity to do so. Some financial acumen is often helpful. Empathy is very helpful. So those are the two most important qualities. At one time, I would always emphasize the technical ability of that person, but really care and love for the beneficiary is very important, as is the ability to step up and manage the trust for the benefit of the beneficiary. Trust amount that they're going to be managing could be, a small amount of money up to multiple millions of dollars. And they're going to have to stand up to, they're going to have the backbone to advocate for, manage for the benefit of the beneficiary. Oftentimes I litigate cases where an interested family member or other interested party is trying to prevail upon the trustee, the successor trustee, to do something that may not be in the interest of the beneficiary. One of the things they're going to have to do is manage that money for the life of the trust, the life of the beneficiary. So they need to do that prudently. Basically, special needs trusts come in three flavors, if you will. One is a third-party trust, and we're talking about, the first or third party as relationship to the beneficiary of the trust. A third-party trust is a trust. Third-party special needs trust is a trust that's created by the grantor for the benefit of a beneficiary who is not the grantor. And different rules, I'll get into those later, apply to how those trusts should be created and the tax and other advantages or disadvantages of choosing one or the other. Other flavor is a first-party trust. That's a trust that's created by the beneficiary, perhaps disadvantaged individual, but has enough capacity to set up a trust to protect their assets. And then another type of trust, and actually this type of trust is one that can be created for either first or third party trusts, and that's a pool trust. And a pool trust is a trust that goes into a pool, which is then pooled with individual trusts for other individuals, and it's managed professionally by that pool. Each of the beneficiaries has their own separate account, so they're not commingled, and the manager of the pool trust, as well as the trustee of the trust, makes decisions on how to fund the needs of the beneficiary.